Good morning, everyone, and IT has confirmed that we are video streaming. We are now on the record, and I am calling this evidentiary hearing into order. This is docket number 223 CONS 3023 CPEN in the matter of the failure of Mike McClenning doing business as production maintenance service to comply with K.A.R. 82-3-111 at the Barton number 3, the HWR number 1, the Moyer number 1, the Welton number 1, and the Wilmoth number 24-1 wells in Montgomery County, Kansas. I'm Susan Duffy, serving as chair and presiding officer for this hearing, and I am joined by my fellow commissioners, Dwight Keene and Andrew French. First of all, I would like to start with entries of appearance, and I will begin with commission staff. Good morning.
Good morning. Thank you. Tristan Kimbrell on behalf of commission staff and the public generally.
Thank you. And operator, good morning. You are on mute. There we go. Okay.
Can you all hear me now?
Yes, we can. Thank you.
Mike McClenning, and this is all Greek to me.
All right. Okay. Well, first of all, staff, do you have any recommendations regarding notice of this hearing?
Yes, notice of this hearing was contained in the presiding officer order setting this evidentiary hearing filed on January 12th, 2023. The order was properly served on all parties. Staff further notes that all parties are in attendance today. Based on these facts, staff recommends that the commission find that the notice is proper and that the commission has jurisdiction to hear this matter at this place and time.
Okay. Are there any objections to notice? Hearing no objections and based on staff's recommendation, I find that notice is proper and that the commission has jurisdiction over this proceeding at this time and place. Okay, we'll move on to preliminary matters, then discuss procedure during the hearing. But first, we have some preliminary matters of my own. We are conducting this hearing over Zoom, and sometimes things do go wrong. If any party encounters a technical issue, please just ask to go off the record. Then we can resolve the technical issue before we go back on the record. Second, witnesses are asked to keep their microphones off or muted when they are not scheduled to talk. And right now, if everybody would ensure that their cell phones are muted, the phones in their offices and other electronic devices, that would be much appreciated. Third, so that the parties are aware, if the commission needs to consult among themselves, we'll go off the record and enter into what's called a Zoom breakout room to discuss whatever we need to. It's kind of like a soundproof booth. Then we'll return from the breakout room and go back on the record. And finally, since we're doing this by Zoom, be really careful to identify exactly what you're referring to when you're discussing pre-filed testimony and other filings. We have copies of everything, so we should be able to follow along. Now, do parties have any other preliminary matters to take up at this time?
Not at this time.
Okay, so in regard to the procedure for the hearing, parties are typically allowed to make an opening statement. After the opening statement, we'll have examination of witnesses. And after direct examination of each witness, there is an opportunity for cross-examination, commission questions, and redirect. Any further examination will be at the discretion of the commission. Following witness examination, parties typically make closing statements and arrange for the filing of post-hearing briefs if necessary, and then we will conclude the hearing. So now let's move to opening statements, and I will begin today with Mr. Kimbrell, serving as commission staff.
Thank you. Commissioners, the outcome of this docket depends on who you think is responsible for the wells on an operator's well inventory. We intend to show that the 5 wells at issue in this docket were on Mr. McClenning's well inventory, and the wells were inactive longer than the deadline in K.A.R. 823111. Mr. McClenning will likely argue that he thought the wells were in compliance, or that he didn't know how to file an exception to the 10-year rule in K.A.R. 823111, or that he transferred one of the wells, or that he eventually plugged 4 of the wells. None of these excuses should absolve Mr. McClenning of his responsibility to keep the wells on his well inventory in compliance with commission rules and regulations. Commissioners, Mr. McClenning did not keep the 5 wells at issue in this docket in compliance with the commission regulations. K.A.R. 823111 provides for a $100 penalty for failure to conform to the requirements of that regulation. Consequently, the commission should affirm the $500 penalty in this docket. Thank you.
Thank you, Mr. Kimbrell. We'll move to Mr. McClenning, if you would, please.
Okay. I really didn't see anything wrong. I had been told in the past that they were statutory or declaratory or whatever you want to call them. And as Mr. Kimbrell said on the Welton well, the T1 was filed years ago, and I tried to get wells off my inventory off and on. And a few years ago, I just give up. I wasn't getting anywhere. And, I think Jonelle may have been over that department back then, or Sylvia. But anyhow, when I talked to her about that, one of them, they told me they had like 1,100 of them on the head of them, and that they'd get to it whenever they got to it. I just let it go. And wells did eventually get plugged. I just kind of had to wait my turn. I mean, I asked Ron to, when we could get there, and, pestered them off, but there was no environmental issues or anything like that. And I did see, okay, something back years ago that a well that was on my inventory that I wasn't mine, and I, put notes on it on the list there. And anyhow, at the time, Jonathan Moyer told me I couldn't represent myself when he was in your spot, Mr. Kimbrell. So I just went ahead and plugged the well anyway. And I sent an email to Mr. Kimbrell and Mr. Myers this morning, asking them, that'll demonstrate that I do comply. And I've never tried to sidestep or anything.
Okay. And Mr. McClenning, you can go in to your statements further on your own self-examination. This is just an opportunity for the opening statement.
Okay.
So do you wish to continue, or do you want to go in more detail?
That's good enough for now.
Okay. Thank you. All right. Now we're going to proceed to the examination of witness. And Mr. Kimbrell, you may call your witness. Since there is not a court reporter, I will be swearing the witness in.
Thank you. Staff calls Ryan Dooling.
Good morning.
Good morning. Mr. Dooling, do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Your witness, Mr. Dooling. Yeah.
Thank you. Mr. Dooling, could you please state your full name for the record?
Ryan Dooling.
By whom and in what capacity are you employed?
I'm employed by the Conservation Division of the Kansas Corporation Commission out of District 3 as a compliance officer and environmental compliance regulatory specialist.
What is your work address?
137 East 21st Street, Chanute, Kansas, 66720.
Are you the same Ryan Dooling who caused to be filed in this docket direct testimony consisting of 7 pages and 2 exhibits, and rebuttal testimony consisting of 5 pages and 1 exhibit?
Yes, sir.
Was this testimony created by you or at your direction?
Yes, sir.
Now that you are under oath, do you have any corrections to make to your testimony?
I do not.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes, sir.
Do you swear the answers contained in your pre-filed testimonies were and are true to the best of your knowledge?
Yes, sir.
Thank you. Commissioners, at this time, I move for the admission of Brian Dooling's pre-filed direct testimony and attached exhibits and pre-filed rebuttal testimony and attached exhibit to the formal record.
Do I hear any objection? Hearing none, it's so ordered.
I tender the witness for cross-examination.
All right, very good. Mr. McClenning, your opportunity to cross-examine Mr. Dooling.
Good morning.
Good morning, Mr. McClenning.
On some of the, I guess your rebuttal for my pre-filed testimony, you have the well inventory list for many years in there.
Yes, sir.
And did you notice, I noticed the ones there would have been the Midwest mineral shoots. Those were the ones that I made notes on. Correct?
Okay. First of all, there is some background noise, and Mr. McClenning, you cut out just a little bit. Could you repeat that?
On the prior year's well inventory list that you sent with your rebuttal testimony, the notes that are on there would have been, they were concerning the Midwest mineral and the Chutes wells, correct? That's where the notes would have been. I can't remember exactly which years, but I know that those are the ones that were on there.
Okay.
The reason there wasn't any notes on the Welton well was that I had contacted Wichita many times over the years to get it resolved, and it never got resolved. And then and that's why you never saw any notes about it.
Objection. Mr. McClenning appears to be testifying.
Okay. Sustained. Just
I'm okay. It's all new to me.
Just ask the witness your questions, if you'll continue on.
I think that's it. That's it.
Okay. All right. Thank you. Mr. Kimbrell, or excuse me, let me go to commissioners. Are there any questions, Dwight Keene?
Yes, thank you. Good morning, Ron.
Good morning, Commissioner King.
From among all the wells that the operator oversees, how did these 5 wells come to be identified as wells that should receive a particular attention by the staff?
District staff had submitted NOV letters to the operator that were referencing to the inactive wells on his license. The operator submitted TAs for all the wells that were on the NOV letter. And out of those 27 wells, I believe there was 5 of them that was denied for 10 years. The 10-year rule had not been produced for 10 years. So those 5 wells are why we are here today. Staff resent a NOV letter for the 5 wells that were denied, with a new deadline to bring those wells into compliance. Those wells were not brought into compliance by the operator by that deadline.
Did the commission staff receive a response to those latter NOVs from the operator?
Not the one with the 5 wells that were denied. I did not receive any information from the operator until after the penalty recommendation was finalized and ordered.
Okay. And I presume that if I'm looking at your pre-filed direct of November 14, 2022, the 27 wells to which you make reference are contained within what is identified as Exhibit RD1 to that filing. Is that correct?
Yes, sir. I believe that is correct.
So if I'm understanding your testimony thus far, Mr. Dooling, among those 27 wells, the only remaining outstanding concerns as of the time of the issuance of the NOV regarding this operator were these 5 wells that are the subject of this docket. Is that correct?
That is correct at that time. Yes.
And what resolution did the operator take with respect to the other, 22 wells?
The other 22 wells, the operator filed CP1 11 applications on those, and those were approved.
Okay. Let me turn to your rebuttal testimony, Ryan, and let's turn to page 2 of that rebuttal testimony. John, if it's possible to for screen share here, that would be good too. If not, it's fine. Freeze that. Go back to the previous. What I'm interested in, John, are basically lines 10 through 22. Can you see this on your screen, Ryan?
Yes, sir.
This, in essence, correct me if I'm wrong, is a description of what is sort of generically referred to as a statutory or declaratory well, as found in K.A.R. 82-3-111 E. Is that correct?
Yes, sir. I believe so.
So as long as these basically 5 criteria that are set forth in the regulation, as long as there's compliance with these 5, then basically the well is deemed basically to be again, generically speaking, a declaratory or statutory well. Is that correct?
That is correct.
So the essence of that is then, is it not that these such wells are roughly the equivalent of producers? Is that correct? As long as there is compliance with this regulation.
That is correct. However, these 5 wells failed to meet number 4 in that reg. The cessation period, but for all the wells in this docket was was more than 365 days. These wells had not been in production for over 10 years.
Okay, and how did you reach that conclusion?
The dates that were filed by Mr. McClenning on the CP111s.
Explain that a little more fully, please.
The operator places a shut-in date on the CP111, which is the last time the well was in operations. And I do not have those forms sitting in front of me, but those dates were over 10 years from the last time the well had been produced.
Okay. So in response to the question I asked initially, I think your answer was that if a well satisfies the conditions of 82-3-111E, it is in essence deemed to be a producing well, notwithstanding the fact that it's your contention that the 5 wells that are the subject of this docket didn't satisfy the prerequisite of item number 4 under that reg.
That is correct.
Okay. So continuing with that train of thought with respect to this reg, a well being statutory or declaratory under this reg is to be distinguished from wells that are identified as being inactive. Is that correct?
Those wells are still classified as inactive wells for status. However, inside of the tab on our BDMS, there's a place that we can actually mark that as a declaratory well.
Okay. All right. All right. So basically, I'm not trying to put words in your mouth here, but again, going back to this reg and the 5 prerequisites to qualify for a well falling under this reg. The primary concern the staff had was in your contention, is the failure to comply with item number 4, not items number 1 through 3 or 5. Is that right?
I believe, yes.
Okay. Just to confirm for the record, in your opinion, all 5 wells that are subject to this docket, have they, as of the present date, been plugged?
4 of the wells have been plugged. The other well, the Welton number 1 well, has actually been transferred to another operator's license as it is being used for a home-owned gas well.
Okay. And when did that transfer take place?
Let's see if I have that date in front of me. I know the well was transferred to Stonegate Ranch, and I thought it was in my testimony somewhere when that was transferred, but I might be mistaken. But it would have been it would have been towards the end of 2022, I believe, is when that well was approved for transfer.
You don't recall that there being a T1 as of 2013?
I was not aware of a T1, no.
We're talking about the Welton number 1, is that correct?
Yes, the well that was transferred, yes.
Yeah, okay. Well, for purposes of argument, again, I'm still making reference to your pre-filed rebuttal testimony as of December 19th, 2022. If we could take a look at the exhibit to this, is not necessarily your screen share, John, but let's take a look at the exhibit to that, or the attachment, which are, as I see it, these are well inventories for the operator from 2013 through 2021. Is that correct?
That is correct. Yes, sir.
Okay. Now, these well inventories that were certified to the commission by the operator as being correct and complete?
Yes, sir.
It looks to me as though the print is awfully small, but it looks to me as though the wells are listed here alphabetically by the lease name to which the wells are identified. Does that seem correct to you?
Yes, sir, it does.
Okay, so if I look down, I'm looking at the 2013 now operator well inventory. And if I scan down and look for that well toward the end of the list, it shows that that well is It looks like oil and gas producing to me. Is that correct?
Bear with me. I'm trying to read this.
Get your magnifying glass out.
Yes, yes, sir. Yes, sir, that it shows producing on 2013.
All right, let's go forward to the 2017 inventory. Again, for the same well, it appears that it shows that that well is oil and gas producing. Is that correct?
That's what he has listed on the inventory. That is correct.
Let's turn to 2018, the next year, the following year. Same drill, look for the same well on the well inventory for that year. And if I'm reading this correctly, it shows that the well is gas inactive. Am I reading that correctly?
That is correct.
So it's showing that it's a gas well, but inactive, if I'm reading it correctly.
That is correct.
And then let's turn to 2021, the last year for which your exhibit shows well inventories. And again, the same drill. Let's look down for that well. If I'm reading it correctly, it shows gas inactive. Am I reading that correctly?
That is correct.
So if I'm looking at this in summary for the Welton number 1, from 2013 to 2017, it shows that it's a producer on the operator's well inventory. And from 2018 through 2021, it shows that it's a gas inactive well on the operator's inventory. Is that correct?
That is correct. That is what it shows.
Okay. All right. Quick check here. I think I'm finished. Mr. Dilling, one check. Let me check. That does conclude my questions. Thank you very much. I appreciate your indulgence.
Thank you, sir.
Thank you, Commissioner Keen. I'll turn to Commissioner French. Do you have questions, please?
I have no questions. Thank you.
Okay, thank you. Mr. Dooling, if I could. So
Yes, ma'am.
you have been employed with the commission for how long?
With the commission since, I should memorize that date. I need to look back. It was June 2004 is when I actually began work with the Kansas Corporation Commission.
That's correct. And always in District 3, is that correct?
That is correct.
Okay. Are you familiar with Mr. McClenning?
I did not work the area that Mr. McClenning wells are located in. I did not become acquainted with Mr. McClenning until I become compliance officer, and this docket arised.
Okay. All right. When you work out in the field, do you get to know the operators over a period of time?
Yes, ma'am. You work with operators every day, so you get acquainted with them very, very well.
Okay. Do you spend most of your time out in the field?
For years, I did. Here recently, when I become the compliance officer, I spent a great deal of time in the office now, but for many years, I spent a lot of time in the field.
Okay. In Mr. McClenning's testimony, though, I think he expresses some concern about the ability to talk to staff and get a hold of staff, and that calls weren't answered or returned. So what do you say to that in general?
In general, I would have to disagree with that. Staff talks to different operators every day throughout the day. And sometimes we get phone calls after hours that if we're not able to take, we return the next morning. I've been employed here several years, and I cannot recall that I'm not going to say that I've ever not missed a call, but staff has always made it a point to contact the operators as soon as they get message that they've tried to call. So I disagree that it would be that staff would not return calls. I would disagree with that. I mean, everybody gets busy from time to time and might not be able to take the call that day, but I believe staff always tries to return calls.
Okay, all right. Okay, that's the only question I had, Mr. Dooling. Let's go back to Mr. Kimbrell. Do you have any redirect, please?
Yes, I do. Thank you. Mr. Dooling, if I was understanding Commissioner Keene's questions correctly, was the Welton number one well on Mr. McClenning's well inventory from 2013 to 2021? And what does it mean for a well? And what does it mean for a well to be on an operator's well inventory?
The Welton number one's been listed on Mr. McClenning's well inventory in those years and was certified as being his responsibility. The status is as producing or inactive is a status that the operator reports. We find a lot of wells that are reported as producing that have not produced for several years. So looking back, we research KGS oil and gas sales records, and a lot of times those wells will surface because it's just as easy for an operator to put producing and not have to worry about following CP 111s.
Since Mr. McClenning indicated that the Welton number one was inactive from 2018 to 2021 on his well inventory, would it be possible for the Welton number well to still be a declaratory well?
No, sir. It is not possible because the well has not been in service within those 365 days.
Thank you. Do you believe that the $500 penalty should be affirmed?
Absolutely, I do. Those rules and regulations were put in place for a reason. Whether, the penalties that come from those rules and regulations, whether it's $100 or $100,000, is not the point. The point is, if we need to uphold the penalty recommendations, that was the order that was placed for future compliance. The operator failed to comply with those rules and regulations, and I feel should be held accountable.
Thank you. I have no further questions.
Thank you.
Okay, thank you, Mr. Kimbrell. I'll turn to Mr. McClenning. Do you have any recross of the witness right now?
I do.
Okay.
Let's talk about the Welton well. In your opinion, since I know you guys got your information from the KGS as far as production records and stuff goes, since it was producing gas and basically has never stopped for the house that's on the property, and the Stonegate Ranch happens to be the landowner too, is why the T1 was done, but where it went, who knows? Why wouldn't that well be a declaratory well?
The information that was provided is why it was denied for the 10-year service.
I mean, I have to admit, it hasn't sold gas through the pipeline, and the pipeline doesn't take it anymore anyway out there. But since it's been producing gas for the house, I mean, but anyhow, it's water under the bridge now. It's over. But I just felt that one should have never been on the table anyway. And had staff and went out there and looked, that it was a scene where it was hooked up going to their house. That's all I got to say about that one. And as far as, I wanted to ask, as far as you thinking the penalty should stand, what kind of a message will you be sending to the other operators like me who comply, maybe not in your little window of time that you guys gave, but I did get it done? What kind of message will you be sending to the other operators if it stands?
I believe we will be sending the same that we always stand by. I mean, I deal with operators on an everyday basis. They when they get an NOV letter, they pick up the phone and reach out and talk to me. And a lot of times this never gets to a penalty recommendation phase. If operators fail to contact and try to work with district staff, then it gets to this stage. So the only time that operators I seem to disagree is when they do not comply. So I do not believe that we'll be sending any mixed emotions if the penalty is upheld, which I stated before I do believe should be.
Another thing you stated earlier about being able to be gotten a hold of. I actually do have a phone record here. And to your phone, I mean, I could look up the dates if you really want me to. There are 10 unanswered missed calls. There is one where you called me and I had to call you right back on the 6453 number. I called the office and left messages there 4 different times. No one returned my calls. And then the 6511 number, you had two return calls, and then I left a message for you. Now, I mean, I don't know what else I could do.
Objection. Mr. McClenning is again testifying.
Well, I'm asking him about the calls, I mean, he made the comment about it. Can you explain why you didn't return my calls?
I'll overrule the objection and if the witness will answer the question.
Mr. McClenning, as far as I can recall, I always try to return your call. The 6511 number is my cell phone that I carry with me, even if I am not in the office. If you left a message, I will apologize if I did not get that message. But I do not recall you ever reaching out to me before you actually received the penalty order. All of our communication started after the order was placed, not before.
You're gonna make me look the dates up, but prior to, I'll admit, I agree. There was a big time there where I just assumed everything was good. Well, I'll give you that. But I did. Well, I'm done.
Okay. Thank you, Mr. McClenning. Okay. Commissioners, is there anything further from you? Okay, great. We will move on. Mr. McClenning, you are serving as your witness. So if you would Raise your right hand, and do you swear or affirm that the testimony you shall give today is the truth, the whole truth, and nothing but the truth?
I do.
Very good. Thank you. All right. At this point, you can, do you have any, would you like to admit your testimony into evidence at this point?
Yes, that'd be fine.
Okay. Is there any objection?
No objection.
Very good. It is admitted. At this point, Mr. Kimbrell, I'm not, or Mr. McClenning, I'm not quite sure. I've never had a witness also quote be the attorney. So what I will do is let you make your statements as you were discussing in your opening statement. If you would like to provide further explanation.
Okay. I just know right and wrong. You know, I don't sit around and read the rules. And I mean, that's what I do for a living, is try to produce oil and gas, and it's a little difficult anymore. And these, you know, I really and truly don't want to, I want to get out of the oil and gas business, to be God's honest about it. It's just too difficult to make a living. And as far as these wells in this docket, I was under the impression that everything was fine. You know, they were sitting there fully equipped, you know, totally shut in, no problems. The only one that was open at all was the Welton well, supplying gas for the house. And I just didn't push on the cementers to get there to, you know, to help me plug them. I didn't see an environmental hazard, really didn't think anything about it. I mean, I know that's me being naive, but that's how it is. And, you know, I just know right and wrong. And I also would like to know if the affidavit of that Tim Welton signed here a while back for me, is it admitted evidence?
Okay, so yes, you did submit an affidavit, and if there's no objection, we would like to take administrative notice of that. Is there any objection, Mr. Kimbrell?
No objection.
Mr. McClenning, we are
Sure.
admitting it. Yeah.
Chair Duffy, this is John Myers.
Yeah.
To make sure the record is clear, we are discussing an affidavit signed by Mr. McClenning, forgive me, who signed that affidavit?
Tim Welton.
Yes, we're talking about an affidavit signed by Mr. Welton that Mr. McClenning emailed to myself and Mr. Kimbrell in the last couple of days. Is that right, Mr. McClenning?
Yes.
Perfect. Thank you. I just wanted to make sure the record was clear on exactly what we were taking administrative notice of. Chair Duffy, if you could forgive my indulgence.
Very good. And all commissioners did receive that.
Okay.
Let's go ahead and continue, Mr. McClenning.
I have one other thing that I would like to just in my own is that I plugged a well several years ago on the Midwest Mineral that wasn't mine. And I emailed the PERTS plugging report to John and to Mr. Myers and Mr. Kimbrell this morning. And I would like to see if that could be admitted under administrative, whatever you call that.
Administrative notice.
Yes, please.
Okay. All right. And so that is the API well number 150992388800000 CP23 form. Is that correct?
I don't know, because my printer wouldn't let me print it.
Okay. All right. Is there any objection to administrative notice of this form?
Yes, I do object. This is a form from 2016, relates to none of the wells. I believe it's irrelevant.
I'll overrule that. We'll go ahead and admit it and take administrative notice of it.
Reason can I
Okay.
say why I wanted to admit it is just to demonstrate that I do try to comply with everything I'm asked, even when I know I was right. I mean, there was a T1 done on that too, and it was filed at the same time the ACO1 was on that particular hole. But there again, it got lost in the shuffle, and I think we were doing them through the mail back then. But that's all. That's all I wanted to say about that.
Okay. All right. Thank you, Mr. McClenning. We'll move to cross-examination. Mr. Kimbrell.
Thank you. Mr. Myers, if you could bring up Exhibit A in the penalty order, page 1.
Yes, one moment. Mr. Kimbrell, Exhibit A consists of 5 pages. I believe I'm on the first page. Let me know. where you'd like to
Page
be.
1 is great. Yes, thank you. Mr. McClenning, is this the letter denying your temporary abandonment application for the Barton number 3 well?
Yes.
When did you shut in the Barton number 3 well?
I don't know exactly.
Was it more than a year ago?
Oh yeah.
This letter that we're looking at, does it give you an April 9th, 2022 deadline to plug or return the Barton number 3 well to service?
April the 9th.
Is it correct that you didn't plug the Barton number 3 well until September 20th of 2022?
That is correct.
So it took more than 5 months between the deadline and when you actually plugged the well. Is that correct?
That's correct.
Thank you. If we could scroll down to page number 2, please. Mr. McClenning, is this the letter denying your TA application for the HWR number 1 well?
Correct.
When did you shut in the HWR number 1 well?
I'd have to look, but
Was it more than a year ago?
yes.
Was it more than a year ago?
Yes.
Does this letter also give you an April 9th, 2022 deadline?
Yes.
Is it correct that you didn't plug the HWR number 1 well until August 22nd of 2022?
Yes. It was.
So is that more than 4 months after the deadline? Correct?
Yes.
Thank you. If we could page down to page number 3. Is this the letter denying your TA application for the Moyer number 1 well?
Yep.
When did you shut in the Moyer number 1 well?
The same time as the rest of them out there.
So it was more than a year ago.
Yes.
Does this letter give an April 9th, 2022 deadline to bring the well into compliance?
Yep.
Is it correct that you did not plug the well until August 19th, 2022?
Correct.
Thank you. If we could skip down to page number 5. Is this letter denying your TA application for the Wilmoth number 24-1 well?
Yes.
When did you shut in that well?
Same as the rest of them out there.
More than a year ago?
Yes.
Does this letter also give an April 9th, 2022 deadline?
Yes.
Is it correct you didn't plug the well until August 22nd, 2022?
Somewhere in there. Yes. That'd be right.
So more than 4 months after the deadline, correct?
Correct.
Thank you. I believe you included with your pre-filed testimony an affidavit from plug-in contractor Ron Cunningham. Oh, and Mr. Myers, you can take down this exhibit. Thank you. You included an affidavit from Ron Cunningham stating that he told you it would take several months for him to plug your wells. Is that correct?
Yep.
Did you contact any plug-in contractors other than Ron Cunningham?
Yeah, but they were even worse than that.
Who did you contact?
One in Oklahoma. The one in Oklahoma ended up being broke. They went out of business.
Did you contact one other contractor?
Oh, I thought, not really. I mean, I'm a loyalty and neighborly kind of guy. You know, they're right here. So that's what I did.
All right.
Yeah,
Mis- Mr. Myers, if we could bring up staff's exhibit 1.
One moment, Mr. Kimbrell, is that what you emailed
What I
yesterday afternoon?
emailed to you, yes, yes.
Okay, hold on.
Thank you. Mr. McClenning, is this a temporary abandonment well application?
Yes, it is.
If you look up at the top left side of the document, does it have your name?
Yes, it does.
And does it have your license number?
Yes, it does.
If you look to the right side of the document, is this an application for the Welton #1 well?
Yes, it is.
Did you file this TA application?
I was told to, yes.
Thank you. Commissioners, I would request that the commission take administrative notice of this application and admit it into the record.
Is there any objection? It will be admitted. Thank you.
Thank you. Mr. McClenning, did you submit this TA application for the Welton #1 well on March 1st, 2022?
I did.
If you look in the middle of the application, it shows that a casing fluid level was taken on September 15th of 2021. Is that correct?
Yep, when I was out there, it didn't hurt to do it.
So you took that casing fluid level?
Yeah, but the fluid level was actually lower than 1200 actually.
Okay. So if I understand your testimony correctly, you claim that the Welton #1 well was transferred to Stonegate Ranch in 2013. Why did you file a TA application for the Welton #1 well in 2022?
Because I was told to.
So did you file false information by claiming that the Welton #1 well wasn't your well?
I guess that's what this hearing will decide. I mean, I was told to do this and that's what I did. I mean, it was on the little hit list and what else am I supposed to do?
All right. And one final question, Commissioner Keene brought up the T1 for the Welton #1 well. Was it approved by staff in September of 2022? Is that your recollection? Mr. McClenning?
What?
Oh, I'm sorry. Is it your recollection that the T1 was approved for the Welton #1 well in September of 2022?
I don't really know when it got approved, but it finally got done.
Do you have
I
any
think-
reason to believe?
I think it got done. Yeah, it might have been in September. I know it was somewhere in there when we were, I think it was the day you, I, and Mr. Myers were on the phone that it was supposedly getting resolved that very day.
Okay. Thank you. I have no further questions.
Okay, thank you, Mr. Kimbrell. I'll now turn to commissioners for questions. I'll start with Commissioner Keene, if you would, please.
Yes, thank you, Chair Duffy. Good morning, Mr. McClenning.
Morning.
When I look at your pre-filed testimony, your direct pre-filed testimony, one thing strikes me. You have a dearth of field experience, do you not? You've been in the field in the oil patch for a long time. When I look through that listing of the things that you've done, you've operated pulling units. That takes a high skill set. You've served as derrick hand on drilling rigs. You have obviously been, how long have you been an operator now?
40 plus years.
I'm sorry, say again.
40 some years, 50 years.
Yeah. So you have an incredible amount of field experience. And it's in kind of in light of that what I'm wondering about when I look at the well inventories that you submitted for years, or that you submitted that have become a part of evidence here. Let me be fair to you too. From 2013 through 2021. Let me turn back here for 1 second. I went through these inventories in some detail with a magnifying glass. And I'm wondering, each year, you have had, since you've been a licensed operator, you have had to certify your well inventory to the commission annually pursuant to your operator renewal license. Is that not correct?
Since
Yet,
2013 or
I'm
12.
sorry.
Since 2012 or 13, somewhere in there.
Yeah,
We've had to do that yet.
yeah. For at least certainly in terms of what's relevant for this particular docket, that's for sure. And yet, in each of these cases, with the exception of the Barton #3, which by my recollection here, by my reference here, shows that that's been a producing oil well from 13 through 21. But in the case of the HWR #1, the Moyer #1, the Welton #1, and the Wilmoth 24-1, with respect to these wells, pretty consistently, these inventories show that these are producing wells from 2013 through 2017, and that they're gas inactive from 2018 to 2021. All 5 of them, not just the Welton, but all 5.
Correct. That's when the pipeline quit taking gas.
In 2018, what caused these wells to go from oil producers to gas inactive?
I don't understand. They're not oil producers. They were gas wells.
Well, that's not what the inventory shows. The inventory shows from 13 through 17 that they were oil producers. Or oil and gas producers in the case of a couple.
Okay. When I filed the intent to drill, that's where that comes in at. Because they were, I was going to take whatever showed up, whether it be oil or gas, which in turn, that oil or gas designation stays with them for the rest of their life.
When you submit the well inventory, which is a first step in the renewal process, it's an early on step. You have to verify those wells. Are you familiar with that step?
I go through, look at them generally, and most of the time you have to put the K.A.R number with them. The Department of Revenue's designation number has to go with each associated lease and the wells attached to it. And that's where they get, that's what I do.
Let's go back to the question I really asked you. I appreciate your answer. I'm taking your answers at face value. I really am, Mr. McClenning. Question I asked was that do you remember, do you know that an early step in the operator renewal process before you come down to paying for it and verifying all the other information that's asked incidental to that renewal process annually, The very first step is that you have to verify your well inventory. Are you familiar with that step?
Oh, yeah.
Then how in the world does the Welton #1 well show up on the well inventories we've been provided to, incidental to this record from 2013 through 2021 on your well inventory when you claim that it had been transferred to another person?
Because it won't allow me, the system will not allow me to delete it. It won't. And I called Wichita about it several times and it won't, I couldn't make it go away. So I just give up and just let it go so the license could be renewed.
So you're saying that the edit function on that particular part of the renewal process was non-functional for you?
It will not allow you to delete a well, no. Or it didn't then. I mean, I haven't tried.
Yes. I understand that. There are certain protections here, to certain safeguards so that we can have a tracing mechanism with respect to every well. So you can't just willy-nilly do that. But there's a process that's inherent in that should have allowed you to do that so that you're not being asked to certify wells for which you have no responsibility. That wouldn't make any sense, would it?
I would prefer they not be there, yes.
Let me go back to the line of cross-examination that Mr. Kimbrell had taken you through with respect to those 5 NOVs. You remember that when he went through and we did a split screen on that. My question is, and correct me if I'm wrong, why did you not respond to those NOVs?
I attempted to.
In what form?
Just phone calls, basically. But I wasn't, I mean, it might have been my own ignorance, but I planned on plugging them and, you know, I didn't think about it really being urgent since there weren't really environmental hazards. And when we got to them, we got them plugged. +1.
I believe that concludes my questions of you, Mr. McClenning. Thank you.
Thank you.
Thank you, Commissioner Keen. I'll turn to Commissioner French. Do you have questions, please?
No questions. Thank you.
Okay. Thank you. Mr. McClenning, just a couple of questions. I believe it was pointed out by Commissioner Keen that you have been a longtime operator and you agreed that you've been a longtime operator in the state of Kansas. And prior to that, even when you were a teenager, you've been working in the field, correct?
That's correct.
Have you ever received a notice violation before?
No.
Okay, but in since Kohler's inception back in 2012 or that time frame, no, actually 2009, I think, you've never had the opportunity to call up on any other incorrect listing of your wells, or you wanted to edit because you were adding a well or whatever?
Yes, I did try. I mean, like I say, you know, I have to go through Wichita to change the list. And like I said, you know, I just ended up giving up and let it go through. And as far as the new wells being added, when you file your intents and the ACO ones and all that get done, they just automatically show up anyway.
Onto your well inventory list. Okay. So who who made the determination that your wells were not the wells that we are discussing here were not an environmental threat?
It's obvious. I mean, it was obvious. There was no issues, fluid levels low. I mean, it was no problem.
Okay, all right. I think Commissioner King asked my questions, and so no sense repeating that. That concludes my questions. Commissioners, any others? Okay. We'll return to you, Mr. McClenning. Do you want to state anything further right now as redirect?
I've said all I need to say.
Okay, all right, thank you. And I'll turn to Mr. Kimbrell for any recross.
I have no further questions. Thank you.
All right, very good. We will now move to closing statements, and Mr. McClenning, we will start with you.
I have none. I've said everything I need to say.
Okay, very good. Mr. Kimbrell.
Thank you. Very briefly, Mr. McClenning has given you several excuses for why the penalty amount in this case should be waived, but those excuses do not hide the fact that Mr. McClenning was responsible for the wells on his well inventory, and 5 of those wells were out of compliance with K.A.R. 823111. Mr. McClenning has brought those wells into compliance, so it may be tempting to simply waive the $500 penalty, but it should be remembered that Mr. McClenning first received an NOV regarding these wells on February 3rd, 2022. It took him more than 6 months to bring the wells into compliance. So it's an understatement to say that Mr. McClenning was not acting in a diligent manner to bring these wells into compliance. Moreover, waiving the penalty in this docket would send a message to other operators that if they just drag things out for long enough, drag things out for 6 months, then they can ignore the possibility of monetary penalties when they fail to comply with commission regulations. So given the facts of this case, commissioners, staff believes that the $500 penalty is an appropriate amount, and we ask the commission to affirm the penalty. Thank you.
Okay, thank you. Before we conclude, I want to see if there are any post-hearing issues, including whether the parties would like to file post-hearing briefs. Parties?
I don't think it's necessary.
Mr. McClenning?
I don't even know what that is.
Okay, all right, great. No post-hearing briefs then. Commissioners, are there any other issues you would like to take up today? Okay, seeing none, this does conclude our hearing in this docket, and we will close the record and adjourn. I do want to thank everybody for your participation in the hearing. Be well, be safe. Thank you.